Donald J. Trump, or as the judge in his latest arraignment called him, Mr. Trump. I, of course, call him Defendant Trump. He was arraigned in a court of law this week for the third time. Third time a former president has been arraigned on criminal charges. He now faces 78 criminal charges against him in 3 separate jurisdictions and 3 separate indictments. First was the New York State Court with Alvin Bragg, who brought the Stormy Daniels hush money case. Next was the Mar-a-Lago documents case in the Southern District of Florida Federal Court, and now in Washington, D.C.'s District Court. We anticipate a 4th indictment coming anytime now in Fulton County, Georgia, but we'll see when that happens. But that's regarding his attempt to steal the election in Georgia. And that's not even mentioning the myriad of civil cases he has lined up, including one here in New York in early October, where the Attorney General, Letitia James, is suing him for more than $250 million and trying to bar him from ever doing business in New York State again. But what I want to talk about today is I want to talk about and debunk all of his claims of innocence and his defenses that he's going to try and deploy at trial in his latest indictment, the stealing or the attempted stealing of our democracy and of our election, and trying to claw back and steal back the presidency that he did not win. So let's debunk his defenses, okay? Now, his first and primary defense will be to delay all of these cases. He doesn't really want to go to trial in any of these cases, and he instead wants to try his case in the court of public opinion. He wants to make statements, accusations, lies, mischaracterizations, so that the public, and he wants to get it so the public thinks he's innocent without having to test the evidence in court, without letting the government present their evidence in court. And he's going to do everything in his power not to have any of these cases go to trial before the election. So that's his first and foremost tactic, strategy, and defense is delay, 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 and never have to face the consequences. Because what does he want? He wants to get elected and then pardon himself or dismiss the investigations, and that's his goal. That's what he's focusing on. But let's assume this latest indictment goes to trial before the election. Let's remember first, though, a couple tenets of our criminal justice system. First, and this is important, all defendants, including Mr. Trump, are innocent until proven guilty. And that's an important thing because proving someone is guilty is exactly what the trial is for. The indictment is nothing but a piece of paper. It's an accusation and a formal charging document that happens in felonies across the nation in almost every jurisdiction. So the trial is where the evidence comes before a jury of his peers, and the prosecution only, has the sole burden to prove the case beyond a reasonable doubt, okay? That's the second tenet, okay? The prosecutor has this obligation to prove the case, and the defendant doesn't have to do anything. They can sit there, their lawyers don't have to give an opening, they don't have to cross-examine any witnesses, they don't have to give a summation, and they certainly don't have to testify at trial or put on a defense or put on any witnesses. They literally can sit there and say nothing and do nothing. That doesn't typically happen. At a minimum, what happens is defense lawyers will at least test the government's case and will cross-examine witnesses and try to poke holes in the government's case so that they cannot prove the case beyond a reasonable doubt. Because if the government does not prove the case beyond a reasonable doubt, no matter what the defendant does, a jury has to find the defendant not guilty. So the prosecutor also has to put on live witnesses who have to swear under oath and swear to tell the truth. And hearsay is not allowed in court. So the prosecutor cannot say, oh, well, FBI agent, didn't Mike Pence tell you that he was pressured? No, Mike Pence has to come in and actually testify about what happened, what he saw, and what did happen to him, as well as all of the other witnesses. Now, some of the witnesses can take the fifth, right? They can say, I take the fifth. I don't want to speak because I fear I might incriminate myself. And so you can imagine many of his misspoke. Many of his co-conspirators who are mentioned in the indictment are in that boat. So if they were called to testify, they would either have to cooperate with the government, which means plead guilty and try to get a deal, or the government would have to immunize them to compel their testimony, or they can take the fifth and you won't get their testimony at all. Mark Meadows is a big question mark because he doesn't seem to be listed in the indictment as an unnamed co-conspirator, but he would be co-conspirator number one in my book. So that leads many people to believe that he might be cooperating. We don't know, but that's why people are speculating that. So what if Mr. Trump, in addition to mounting a vigorous defense and vigorously challenging the government's case, does choose to put on a defense? What could that look like? What are the things he'll assert at the trial? Will he take the stand and testify in his own defense? He doesn't have to, but if he does, he'll subject himself to cross-examination. And if he lies, he could be prosecuted for perjury. Whether or not he testifies during his trial will be a decision he makes with his attorneys during the trial, and we really won't know until the very end what he decides because he can change his mind at the last minute. It's one of the last things that happens in a trial after the government finishes putting on their case. That's when the defense starts putting on their case. But what are the types of defenses and strategies Trump will deploy in this indictment? What is he going to say? So we kind of know because he's already signaling most of them through his lawyers, again, in the court of public opinion. But we also know, just because it's obvious from the case, any lawyer who has ever prosecuted or defended criminals could say, these are the things he's going to do. So number one, he's going to argue venue and that he can't get a fair trial in Washington, D.C., and so it should move to a friendlier jurisdiction. He's already said this, and he wants to move it to West Virginia. Venue, though, is always in the district where the offense was committed. That's why the Mar-a-Lago documents case, if you recall, was originally presented to the District of Columbia D.C. grand jury. But then upon further analysis, they thought better of it and moved the whole case down to Florida, even though D.C. would be a better jury pool for the prosecution because Florida, especially in Fort Pierce, is sort of a red meat state. But that doesn't matter. You don't get to pick and choose your venue. The venue is where the offense happened. Most of the Mar-a-Lago documents case happened in Florida, so that moved down there. A defendant has a constitutional right to an impartial jury, and that's one of the things that Trump will argue, is that because D.C. voters, by and large, did not vote for him and are not favorable to him, and this is where the Jan 6 insurrection occurred, and the residents of Washington lived it, they experienced it firsthand, and therefore they can't be impartial. So much publicity was surrounding the events of that day, and the delay of the congressional certification of the votes, as well as the hearings, right? The Jan 6 Select Committee of Congress, those hearings occurred in Washington. So they're going to say that they can't get a fair trial there, too much publicity. But the government will say look, the publicity was everywhere. The whole country is the victim of this crime, not just the Capitol, because he tried to steal our democracy. He's tried to steal the election. And so he's not going to be able to get a change of venue for that reason. It's presumed that jurors can be fair, and that's what you have, what's called a voir dire process, where you ask questions of the jury and you will get a fair jury. But also it's important to keep in mind what the standard for a change of venue is to get a fair trial based on publicity. Number one, the publicity has to be prejudicial, it has to be pervasive, and it has to be in the minds of the juror at the time of trial. However, since most of the pretrial publicity will be of Trump's own making, because he's the one who gives all the press conferences, he's the one who goes on TV, he's the one whose lawyers will be talking. You're never going to hear from the government. Jack Smith gave, a 5-10 minute press conference where he just said, there's been an indictment, this is what it's about. It's the only time you're going to ever hear from the government, except when they speak on the record in court. That's the way it should be. That's the way it is. That's the way the ethics guidelines are. So while Trump is trying this case in the court of public opinion, the government, the DOJ, the special counsel cannot fight back. They can't say anything. That's why people like me are fighting back and speaking on their behalf, because somebody needs to get the message out there about what the truth is. And so Donald Trump, though, can't create the very situation that he wants to then benefit from, right? He he can't make it so that, oh, there's so much publicity here in DC, so let's move to West Virginia. He created it. He can't then benefit from it. If that were the case, it would incentivize all defendants to do that, to go to a more favorable location and to judge shop and venue shop. Okay, and that's not allowed. Okay, that's the first thing he's going to argue. What's the second thing he's going to do? He's going to try to get the judge off the case, right? He always does that if it's a judge he doesn't like, right? He'll try to get the judge off the case, saying she's already sentenced many of the January 6 defendants harshly, and she said things like presidents aren't kings. So he's going to use that as a reason to try to say she should be kicked off the case for a conflict of interest. She should be recused. That the standard for that is 28 United States Code, Section 455A, which provides that a federal judge shall recuse themselves in any proceeding which their impartiality may be reasonably questioned, right? And that they have a duty to recuse themselves when they either have a financial interest in the case's outcome, that comes up in civil cases, or where there's a strong possibility the judge's decision will be biased. Trump will have an impossible time making the argument that Judge Tanya Chutkan is biased or that she's not impartial. She has an excellent reputation. She was a defense attorney for many years before becoming a federal judge, and so she's not even pro-prosecution by trade, right? She's fair. And he will obviously call her racist because she's a woman of color. And, in a matter of time, he'll look for reasons to call her objectivity into question and try to create bias where there isn't one. It won't get him anywhere because, the fact is, if you noticed, and the media reported this, there were 7 federal judges at Trump's arraignment in the audience. That's very rare. I don't think I've ever seen judges come and watch any arraignment in court. But it was a show of solidarity to the judge and the magistrate who sat and listened to this case, because Trump is a bully. He's going to try to intimidate the judge, just like he has with Judge Merchan in his Manhattan DA case. He hasn't said anything about Judge Cannon yet, right, in Mar-a-Lago, but that's because he appointed her, and she's already shown to rule in his favor. But trust me, if she starts to rule in ways that he does not like, you'll see that come to an end quite quickly as well. What's the third thing Trump is going to try and argue in this case? He's going to try to relitigate the 7 states where he said he won the election, the false elector states, right? That's where he said there was fraud, there was dead people voting, and he went to court more than 60 times to try to say that there was fraud and that the election should not count in those states. He already litigated them, and he lost every single one. But he's going to want to relitigate this in court and show that they weren't fake electors. So you're going to have little mini trials within the big trial. And Jack Smith's indictment does open this up because it goes state by state, outlining each and every step that Trump took to pressure the state officials and try to change the outcome of the elections. But Jack's going to have to prove that the pressure campaign was illegal, and he will. And we're going to watch Trump try to talk about how there were irregularities, and he's going to try and delay the case by testing each of those again. The court's going to have to find a balance between allowing Trump to mount a defense, because he has a right to, but not completely relitigate these issues anew if it doesn't have anything to do with the crimes that are charged here, right? And they're not going to let him, for example, relitigate it to the point where he gets a recount in one of these states or a new audit in these states. And no judge is going to allow that. But can he in some way test kind of what the findings were in each of the states? A judge will give him some leeway to do that. But at the end of the day, what it's going to show, the evidence will show, is that no, Trump was trying to get people to commit fraud for him. That's what's going to come out in those little mini trials that will occur during this trial. The fourth thing he's going to do is he's going to try to argue that he had a First Amendment right of free speech to say these things. It's just words. It's just words. All I did was call Brad Raffensperger and say, find 11,370 votes. I do anything other than that. All he did was call Mike Pence and ask him to, just just say that there's conflict and send it back down to the states and let us Republicans and me do the rest, right? Just words. The First Amendment's right of free speech. I'm allowed to do this. I'm a politician. Politicians say things all the time. That's going to be one of his defenses in the court of public opinion, and he'll try it in court too. However, the First Amendment's right to free speech is not absolute, and there are reams and reams and reams of case law putting limits on free speech. I learned about it in first year constitutional law. One of the famous ones is you can't yell fire, and you can't just run into a public theater and just yell fire for no reason and cause a stampede and people get hurt. You can't do that. You don't have a free speech right to do that. Many people have said on the air, and I've watched it on TV, that Tony Soprano in The Sopranos can't go up to one of his henchmen and say, "Go whack one of my rivals," and then not be held responsible, saying, "Oh, it's just words. I didn't pull the trigger. I didn't do anything." You can't walk into a bank and say, "Give me all your money," and then when they get arrested for bank robbery and say, "It was just words." So you get the picture, right? You can come up with a million of these examples. And, every fraud crime has an element of speech to it. And the law doesn't allow you to hide behind that. So when speech becomes an action, that's when it's no longer protected by the First Amendment. The First Amendment does, though, protect you from lying. You can lie, right? You can lie and say whatever you want. I can say the sky's red and, that I'm, 20 years younger and all the things we want to lie about, right? But you can't lie and defame someone, right? So Donald Trump, who lied that he said he never met E. Jean Carroll, never had sex with her and called her all those things, he was lying, but he defamed her. So he wasn't allowed to do that. And you can't lie if it causes a fraud. And you can't lie about things like, think about if like a food manufacturer lied about the ingredients and someone got sick from it, you can sue them and they can't say, "Oh, it was just words on the box," So you get the picture, right? There are limits to free speech. So Trump had every right to challenge the election with his words. He could even say he thought he won and that he thought the election was stolen. He can almost say anything he wants about it, and his speech will be protected. He can also challenge it in court. That's what he has a right to do. But what he cannot do is use his words to then set in motion a series of events coupled with a pressure campaign, threats, and then ultimately violence in the Capitol in order to literally steal a legitimately won election and then claim it's just speech. So that's not going to fly. Some people are saying, and this is sort of, I think, controversial, is that he believed he won the election. And if he believed he won, Jack Smith has to prove beyond a reasonable doubt that he knew he lost. I'm not sure about that. There's no element of any of the crimes, you can look them up yourself, that says he must have believed he lost the election and then he was doing this anyway. I think there will be evidence that he did know that he lost. Alyssa Farrah Griffin, who's on The View and who's often on CNN with me, she says that he said to her, "Can you believe I lost to this guy?" meaning Joe Biden. And there are other examples of that as well as you're going to have a parade of Republican advisors, including his White House counsel, his attorney general, his acting attorney generals, and others who will tell you that they told him and explained to him that he lost, including more than 60 court cases, and judges who will say that. So there will be substantial evidence to show that he knew. However, let's say for argument's sake, he actually does believe he won. Maybe he's such a narcissist that he does believe it despite the objective evidence to the contrary. Other than the pillow guy, the overstock guy, and the crazy woman who told him he lost, he really, there's no objective way that he could think he did. But let's say, even if he believed he won, the law still doesn't give him the right to threaten Brad Raffensperger, right? And tell him how dangerous it will be if he doesn't find these 11,780 votes. It doesn't give him the right to pressure, solicit, encourage state officials to violate their oath and overturn the legitimate vote results in their states like he did to Rusty Bowers. He is not allowed to purposely cause fake or false or illegitimate, whatever you want to call it, slates of electors to be created, because that's outright forgery or fraud. It would be like me writing a check for $1 million, buying a house, and then the check bounced, but I'd get arrested for stealing the house. I can't say, oh, First Amendment, I can do it. I can lie. I can do whatever I want. You can't pressure Pence to not accept the vote result of a legitimate, secure, democratically conducted election. And Pence, who actually had his own interest in the outcome because he was standing to win that election if Trump and he won. He's not allowed to say to him, just don't certify it and leave the rest up to me and the Republicans. And he can't ask the DOJ to say there's fraud when there isn't. They investigated his claims and there simply weren't any. He can't use fraudulent and deceitful means to organize fake electors to literally steal the election from the American people. So even if he, in his own way of thinking, in his own mind, will somehow say, but I thought I won, it still doesn't give him a right to do the things that he did, because those are crimes. You don't have a right to, I think I should be able to, I think I should be able to shoot someone, because they upset me. The law doesn't allow me to do that, right? Even though I think it should. I think that should be the case. It doesn't matter. You're not allowed to do certain things, and the law governs that specifically. The sixth defense he will have, he's going to say, is I relied on the advice of counsel in the fake elector scheme. That he's already getting that one out there. Now, what is the advice of counsel defense? It is a defense. In a nutshell, it says if you seek the advice of counsel from an attorney, give her all the material facts that you have, and they tell you what to do, and you follow that advice in good faith, this can absolve you if you inadvertently end up committing a crime because you genuinely tried not to do the wrong thing. Think about a situation where, I don't understand the tax code, and I want to pay less taxes. So I go to my attorney and I ask, can I move this money into a certain kind of account and avoid paying taxes? And the attorney looks it up and says, yeah, I think you can. And I do that. Well, it turns out I can't, and it's not legal. Well, if the attorney had a good faith basis for interpreting the law that way, but got it wrong, but I in good faith relied on that, I'm not going to be prosecuted for that crime. I probably have to pay the taxes back, but I'm not going to be prosecuted for that crime. That's what the advice of counsel is. It's a good faith thing. Now, Jack Smith will show that dozens and dozens of lawyers, Trump's lawyers, White House counsel, his attorney general, et cetera, all told him he can't do this, but he didn't like that, right? He didn't like this advice. He had a means to an end, right? He wanted someone to tell him how to do this. And he went and looked for lawyers. He found lawyers and advisors that would craft and devise this plan, this illegitimate plan for him so that he could do it. It's the reverse of the advice of counsel, since the client is the one driving the bus here. And as Judge Carter said, when finding that the crime fraud exception applied to certain notes and conversations between Trump and his attorney, John Eastman, also known as co-conspirator number 2, that Jan 6 was a coup in search of a legal theory. Well, that's what Donald Trump was here, right? This was a plan in search of an illegal plan in search of a legal theory. And if you hear someone say, well, Kennedy did it in Hawaii in the 60s, don't let that distract you, okay? That's not actually true. That's apples and oranges. Literally, in that case, the vote was such a close call, like down to 2 or 3 votes, or like a handful, like single digits of votes, that they didn't know who won. And so at first, Kennedy's rival won. And so they created that slate of electors, right? But while they were hand counting the votes again, because it was so close, by law they had to recount it, Kennedy said, you know what, let's just do the second one just in case, right? Just have both of them ready, just in case. And guess what? When they did the recount, Kennedy ended up winning. And so they used those electors. So actually it wasn't fake. It's like the Super Bowl, right? And when you have the Super Bowl, they make thousands of t-shirts saying both teams won the Super Bowl. Because when somebody does win, they break open that box and suddenly hand out thousands of t-shirts, right? And then the other box suddenly becomes, trash. And they do it it's not like they don't have any t-shirts, and then when someone wins, they go print up 1,000 t-shirts like in a second and then pass them out. So it's totally different than what Trump was doing here. The other thing Trump is going to try to do, the seventh thing he's going to try to do, is he's going to try to preclude Mike Pence from testifying about the conversations they had, saying executive privilege. And Pence might even try to keep himself out and keep himself off the stand, saying, no, I have a speech and debate clause privilege that protects me. But both theories have already been rejected multiple times in court. The executive privilege doesn't apply because it's within the same branch, right? It's to protect someone in the executive branch being compelled to testify in the legislative branch and vice versa, and compelling them to give information in all three branches, right? But Trump and Pence are in the same branch, and Jack Smith is in the same branch, right? They're all in the executive branch. So, and plus the executive privilege belongs to the current executive, who is Joe Biden, who I doubt, will object to this testimony, but it will be very bizarre, I will say, for the vice president, Pence, to have to testify against the president who he served for 4 years. And he is front and center, one of the stars of this show, right? He took notes, and he's very much going to be a witness in this case. And Pence will probably try to assert the speech and debate privilege, which he already has in a prior court proceeding, because although he was in the executive branch, when he certifies the election, it's as president of the Senate. And the speech and the debate clause basically says that anyone in the legislative branch, so the Senate or the House, has a privilege and can't be questioned about their actions in court that are in conjunction with legislative activities. And Pence will be able to assert that probably about regarding certain things that happened on the day of January 6th when he was certifying the election at the Capitol, but not everything, not the before and not the after, and not the violence that he was witnessing and having to be whisked away and all of that. So the entire pressure campaign will come in, and most of the evidence and testimony will come in. My thought is that none of these defenses will ultimately absolve Donald Trump of any of these crimes, but ultimately the prosecutor has to prove them all beyond a reasonable doubt to 12 jurors, and each one has to find each element beyond a reasonable doubt, and they all have to agree. So even if one juror does not agree, the jury will be hung and he'll have to be tried again. And all of them have to agree to acquit as well and find him not guilty. So it's hard to get 12 people to agree on anything, right? What do you want for lunch? What movie do you want to see? Let alone that you can prove all elements of a crime beyond a reasonable doubt. But if you read this indictment that Jack Smith brought, it's beautiful and simple in that it's written in plain English so that anyone can understand it. And it's streamlined. It's one defendant, and it's 4 charges. And that's a clean, simple way to present a complicated set of facts. So stay tuned and stay informed. I'm Karen Friedman Agnifilo with Legal AF. Watch us every Wednesday and Friday at 8 p.m. Eastern. And thanks so much for listening.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.